talking about this as one of the most shocking stories of his life. It then creates a certain element in this documentary to say it seems like Mr. Thabo Bester, who is fully a center of this documentary, is already found guilty in a documentary. And why am I saying this documentary is still about Mr. Bester? Because they say the beauty and the Bester. Who is Bester? Is Thabo Bester. Now, we know the phrase Beauty and the Beast from one of the old movies. Now, the Beast no longer exists. Who exists? The Beast has been replaced by Bester. So it means that in the nearer future, we are likely to have a situation whereby when kids are asked, what do you know? They won't say the Beauty and the Beast as we knew in the literature of English ourselves, who grew up during that time. They will say the Beauty and the Bester, meaning that the beast has been replaced by a certain individual. Now we have a beast in person and personified into the person of Thabo Bester. So then this documentary, from its naming angle and perspective, it has already brought what we call a serious defamation to the person of Thabo Bester. And we cannot sit and keep quiet when Thabo Bester, who is my client and the applicant in this matter, is being termed or rather narrated as the beast. At paragraph 28 and 29 of the founding affidavit, Mr. Bester alleges unlawful exploitation of his personality rights. There is no exploitation of Mr. Bester's personality rights. A documentary about an alleged escape from one of the most secure prisons in South Africa is clearly in the public interest. Moreover, this documentary deals with broader issues of global significance, including social media, gender-based violence, public safety. Netflix is entitled to commission such documentary. If there is a course of action based on this, it can be addressed later in civil action. For now, the public is entitled to make up its mind about the prison system is alleged to have allowed a convicted man to escape from a maximum security prison. Now, reading paragraph 27, it creates an impression of saying, this documentary will simply come and say, we have done our research, we have the facts, we have found the truth, Mr. Bester has escaped. But there is no court that has declared, that has made a judgment on that. And if they say the public is entitled to make up its mind about how prison system is alleged to have allowed a convicted man to escape from a maximum prison, a convicted man has escaped from a maximum prison, they are already creating an impression of saying he must be found guilty. And that's where now we are talking about a fair trial right being eroded or violated. And also, now I want to direct the court specifically to this phrase that says, there is no simply basis upon which a notorious public figure, such as Mr. Bester, can seek to censor speech about simply because he has not given consent. Now, because there is Mr. Bester who is purported notorious, and this has to be questioned, how do we conclude that somebody is notorious? Is there a measure that Netflix uses to declare somebody notorious? Do we have 1 to 10 to say Mr. Bester is notorious? When you cross the bar of 8 allegations or accusations, that's where you are notorious. Or how did they conclude that he's notorious? And having said that, they still come to say there is no way he should consent. It means that now the right to dignity of Mr. Bester is in question. He has no rights anymore. He can be spoken about as if he's just a piece of meat that has no feelings, emotions, or mind. Then that's where the court needs to look into this documentary as a violation and erosion of human rights. Because if Mr. Bester is notorious and we can talk about him anyhow and have people speaking there and declaring him guilty as if they've got all the facts right and the court has backed their claims, then we are having a challenge in South Africa when it comes to protecting human rights. And also, I want to bring a very interesting point in this to say, you know, the way this documentary has been sensationalized and the vibrations of it, including the emotions created, there is somewhere one speaker on that documentary says, "Are you dangerous?" And they they edited it, putting Mr. Best on the other side, saying, yeah, as if he's answering that question that he is dangerous. Now, that is manipulation. That is artistic manipulation. Very wicked craftiness of the editors of this documentary. Because they are sitting there, putting stories as if he is confirming that indeed he is a dangerous man.
Where is this in your papers?
It's there in our papers. In my funding papers is there. It's there in my papers. Everything I'm saying is in my papers. I will not waste court time and speak from my mind. We have that in our papers. So now, this also shows that this documentary simply tries to drive a certain narrative about Mr. Thabo Bester. And now, if we have this kind of a documentary being flighted, whereas on the 19th of September, next week, Friday, he will be appearing in court, what is the impression that is being created there? And also, these are type of documentaries that make the public to believe that somebody is guilty. When they are not found guilty, then the judiciary will be looked at with wrong eyes or will have a bad reputation simply because there were some prominent people, celebrities, who were speaking, social commentators, that he is guilty. And this is so emotionally created that it becomes one of the greatest assets of manipulation that you look into this documentary. I saw one of the celebrities, well-known figure, crying. I wonder, why is she crying? What does she know? Was she there? So these are some of the questions that we really look into. And also, one of the impressions that Netflix or the Respondent is creating is to say they are listing a number of articles that have been written about Mr. Thabo Bester. To say it has been written about his rape cases, his Facebook, whatever. They bring many articles that they Googled and they printed them and brought them to court. Now, my question is that because there has been so much published unfounded without having the actual proof of that, should we allow the further publication on that? Is that how things must be? Because some articles have been written in some newspapers, some video clips have been made on social media. Must we allow also Netflix to do the same? And Netflix has already described itself as one of the giant media houses that says it has got 300 million, how many? 300 million subscribers or viewers. Now, if Netflix published this tomorrow, this documentary tomorrow, just for 1 hour, with their 6-point-something million followers in South Africa, it means that in a space of 1 hour, after this radical marketing that they have undertook with this trailer and this documentary through the trailer, it means that we are going to have many people seeing this, and after to see this, a public opinion and the public court would have decided otherwise about Mr. Thabo Bester. Then when that has happened, the question I'm having is this: are we still gonna have are we still gonna have a fair trial in that regard?
Sorry, are you saying that a documentary will influence a court, a judge?
I'm saying
because I find that quite preposterous. Because let's just take it to the end. A judge can only make a finding on the evidence that's before him, and it can definitely not be on a documentary.
I am saying a right. What I'm saying, which is in my papers, I'm saying a right to be presumed innocent until proven guilty, which is section 35. Subsection 3 of the Constitution needs to be protected. This documentary, I'm answering your question. Allow me a space to elaborate my answer. I will answer you fully, my lady. I am saying section 35, subsection 3 of the Constitution, a right to be presumed innocent until proven guilty, has to be protected, including even with a notorious person as labeled by the respondent, like Thabo Bester. Why? Because should that be, when he is found guilty, we do not know what influence will that be. We don't know the amount of influence will that documentary be having in that proceeding. And we are saying such documentaries carry a weight into the public court, carry a weight into the public opinion and interest of the people. And also, my lady, hear my argument within the context of everything that I've been saying for past 30 minutes or so. I have already said, in this documentary, we have the accused, one of the co-accused, who is speaking, the father of Nandi Pamaguduma, and I'm repeating that. And she says, I could not imagine my daughter doing such a thing. It's left there so that people can go and watch the documentary to hear what such a thing will my daughter be doing. And now we also have a judge, Justice Cameron, speaking in that documentary, saying, as a judge, I have never seen such a thing. What a thing is that? Definitely we are talking about Thabo Besta's alleged escape, which already the answering affidavit have stated that this documentary is about that. Now, my argument says, when such documentary are flighted or broadcasted, we then are standing in one corner of the truth, because he is also not given a right of reply. But that is not part of this argument. It's part B of the argument. I'm just saying it in passing because it has to balance my argument. Part B has to balance my argument in part A. So, the court finding him guilty or not finding him guilty, the moment he goes on the street and is not found guilty, because I believe that he's hiring lawyers like us so that he should not be found guilty. He will not be found guilty, I suppose. Then the state has failed to prove his case beyond reasonable doubt. Now, already the documentary has stated some kind of their truth or some kind of their baseless facts to say he has escaped. Now, it means the judiciary of South Africa allows somebody to walk free who has been found guilty by the public opinion. I am addressing the public opinion, and I'm speaking about the fair trial here. And I'm speaking about the right to be presumed innocent until proven guilty. And that cannot be left unattended. Now, having argued all this, my lady, the question is, why are you in court and sweating so much, Advocate Myla? The reason we are in court is because we are asking that this documentary should be interdicted. On which base do you want this documentary to be interdicted? There is a case, as I'm closing, there is a case of Setlogelo versus Setlogelo, which is there on my practice notes. The case has laid down very important requirements for an interim interdict. Number one, it stated that a prima facie right, though open, what is required for an interim interdict to be granted by the court? Number one, a prima facie right, though open to some doubt. That's number one. Number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. Number two, the absence of an adequate alternative remedy. The absence of an adequate alternative remedy. Number four, the balance of convenience favor the grant of the relief. Number five, the balance of convenience favor the grant of relief. Then the last one. Oh, this is me reasoning. This is the fifth. The fifth one will be the balance of convenience favors the grant of relief. Now, my lady, when you look, when you look at our founding affidavit, the applicant has covered all the requirements set out in Setlogelo case. Number one, prima facie right, we have already stated that there is a right to fair trial, which is section 35 of the Constitution, a right to be presumed innocent until proven guilty, which is section 35(3) of the Constitution, and also a right to dignity, which is section 10, a right to equality, which is section 9, and also number two, a well-grounded apprehension of irreparable harm if the interim relief is not granted. There is a phrase we use there to say once the bell is rung, and the documentary is flighted, what then will be of Mr. Bester? And people have seen the story, have heard whatever that has been heard. What more will be? Obviously, there will be irreparable harm. After the documentary has played for 1 hour or 2 hours, since they said it's 3 parts, after the first part, they are done with Mr. Bester. He's already guilty by the format of the trailer. Number 3, the absence of adequate alternative remedy. If this documentary of Netflix is not interdicted, my lady, what more will remedy be for him after it has been flighted or broadcasted to 300 million followers of Netflix in 160 countries as they boast? Definitely Mr. Bester, in every corner of this world or planet Earth, he will be known as a man who faked his death and escaped, because we saw it in the trailer. It's there. And number 4, the balance of convenience favors the grant of the relief. I mean, when you read what the respondent says in their papers, they say the reason this has to be played or flighted is because they cannot keep their their followers or subscribers in suspense, meaning their subscribers are more important than the human rights of Mr. Bester. Their intellectual or emotional tickling and their feelings must be created at the expense of Mr. Bester's rights. Now we also have we also have the convenience. The convenience favor the grant of the relief. What more will be convenient for the court except to order an interim an interim interdict? I do not see any possible way except this. And the court must note in our papers, we do not say this must not be unpublished. We say let the trial end and they will publish it, whether he's found guilty or not. They will even have more, because it will have even the trial in it. It will even have this part. So they will have a bigger meat to give to their 300 million subscribers. What we are not doing this application to curtail the free flow of information. Perhaps at the time when they do this, Mr. Bester will be granted a right to reply. So my lady, having said that, this brings me to the conclusion of my argument to say, if there is one thing that I will argue the court should do, is to simply grant an interim interdict of this documentary. Allow the court to make a decision on Mr. Bester's case, looking into the constitutional right of Mr. Bester. Number 1, a right to be presumed innocent until proven guilty. Number 2, a right to a fair trial. Number 3, a right to dignity. Number 4, a right to equality and protection of the law equally. Having said that, I thank you, my lady.
Thank you very much.
An accomplice or a victim. The claim that is made is that those 3 statements mean that the fair trial rights of Ms. Makutumana and Mr. Bester will be vitiated. If we start with the first statement, the statement from the father of Dr. Makutumana, who says that, I cannot imagine that my daughter would do something like that. It's actually nonsensical to claim that that statement implicates Dr. Makutumana in anything. If anything, it's an exculpatory statement, because the father says the allegations are just not believable. And there's no statement there that says that she is guilty of anything. If we go to the second statement by Judge Edwin Cameron, the statement is simply that it's the most astonishing thing that he has witnessed in his life, or indeed as a judge. That again is a neutral statement. It does not implicate anyone in any wrongdoing. And then we go to the third question from the commentator or the narrator, who says that rhetorically, is Ms. Makutumana an accomplice or a victim? Now, what our learned friends are saying that you must read into that that it implicates Mr. Bester. But it simply doesn't. It's a rhetorical question, whether or not she is an accomplice or a victim. All of those three questions will be dealt with in the trial. So when you look at the content of the statements themselves, the content of the statement is neutral. It does not implicate anyone, and it doesn't suggest that there is a statement of guilt in whatever manner whatsoever. And then you say, they also say the problem is that Mr. Sikelin is a co-accused. But that is also an irrelevant factor that he is a co-accused. The fact is that he is making a statement to express his astonishment that he cannot imagine that his daughter would do something like that, which could in fact be interpreted as my daughter is innocent because she is not capable of doing something like that. And then you also hear that, well, Judge Cameron is a judge. In fact, in Mr. Bester's application, the statement is made that he's a judge of the High Court, so they didn't even bother to do a due diligence there. Judge Cameron does not say that anyone is guilty. He just says he's astonished at the facts that he has uncovered. And we know what facts he uncovered, because he uncovered facts in his capacity as the inspecting judge of prisons. And he presented those facts initially to the media to ground up, and then secondly to Parliament. And those facts are now widely known. And the facts that he uncovered showed that there had been an audacious escape from prison, and that Thabo Bester had been involved in faking his death. So those are facts that are generally known, generally published. They don't suggest that anyone is guilty of a crime that will be dealt with by the trial court itself. And then the last statement, which is, well, is she an accomplice or a victim? That again is a question that is a reasonable question to ask in the light of what is known. So not only are these facts generally public, they are also the subject of judicial commentary. The first judgment at paragraph 46.1a is a judgment of the Supreme Court of Appeal delivered on the 16th of May 2025. That judgment described Ms. Magudumana as having been a fugitive from justice. It also gave the following summation of the facts at paragraph 2 of that judgment. The appellant, and that was Ms. Magudumana, was at some stage at least the girlfriend of the convicted and sentenced rapist and murderer. You will recall that there was a complaint about those words, but they come from a judgment that he's a rapist and a murderer. Thabo Bester, who was serving his sentence at the Mangaung Correctional Center in Bloemfontein. And then look at what happens next. Before his escape from that facility in about May 2022, several suspects linked to that escape were arrested and are facing charges in the Bloemfontein Magistrates Court, including defeating the administration of justice, violating a body, aiding an escape from prison, corruption, and arson. The appellant, that's Dr. Magudumana, is one of those suspects. And look at how they deal with this. So they've said Thabo Bester escaped from prison. And again, you know, this is a serious court. We are all adults. The man was serving life in prison. He got out of it. He was not released by the system. So he escaped. I mean, let's not play around. And then when they talk about Dr. Magudumana, they say she surreptitiously left South Africa. And you remember what had happened is that she left the country without using her passport, and that is what is in the bail judgment. Some months later, she was located in Tanzania and brought back to South Africa. And when she was found in Tanzania, she was with Thabo Bester. Before her arrest in Tanzania, the appellant was a fugitive from justice, and a warrant for her arrest had been issued. She subsequently appeared before the magistrate before the Bloemfontein magistrate who authorized the warrant for her detention at the Bizama Kate Correctional Center in Kroonstad. So that is all facts summarized by the Supreme Court of Appeal. It would be astonishing if the media were prohibited from repeating these facts, which is what that documentary on the parts that have been quoted is suggested to imply, that the man is an escapee and that the lady has aided and abetted the escape. And then it goes even stronger when you look at the outcome in the bail appeal. We deal with that at page 00817 at subparagraph B. Now, this was when Ms. Makutumana applied for bail, and the High Court had rejected the Magistrates Court had rejected the bail application. Now, what's important here is to look at the actual judgment, judgment of Jordan by Justice Jordan AJ. Because it also is actually, yes, it is it's at page, yes, 004/180. That's where it starts. What he says about what had happened, I want to just refer your ladyship to a couple of passages. The first is that there is evidence from the investigating officer, which is cited at 004/186, paragraph 11. And this is what the investigating officer found. It says, in this regard, the evidence of the investigating officer started off with him stating, my investigation revealed that accused number 1 was promised 7 million rands to orchestrate the escape. He enlisted the assistance of his accused, that being accused 3, 6, and 7. He later further testified on the charges that in count 3, the offense is in contravention of section 3B of the Act 12 of 2004. I think that's the Corruption Act. That is corruption. The applicant and her co-accused acted in the furtherance of a common purpose. Their aim, and that includes Ms. Makutuman, was that Bester must escape. The objective evidence of a bank statement shows that the applicant was also on occasions a source who provided the money to accused 1 for distribution to their co-accused. So Ms. Makutumanda took the cash, he distributed it to the officials at the correctional facility. So far, it has been established that the applicant paid 85,000 rands to accused number 1. That's Ms. Makutuman. Then the following passage, they cite the crime of corruption. That's not relevant. We don't have to bother ourselves with that. And then later on at page 004/190, paragraph 17, at the end of that passage, this is what is stated. It says, in this instance, there was no admissibility challenge. In other words, the admissibility of the evidence of the investigating officer, founded upon convincing evidence, calling into question the admission of the evidence of the fingerprints evidence, showing that the appellant claimed the body of the deceased at the mortuary. So her fingerprints was found at the mortuary, that she had actually claimed the body. The witness statements and the documentary evidence. This court cannot find any misdirection in this finding of the court of core. And if you turn over the page at paragraph 19, 004/191, it goes further. It says the judgment was in ground 11 of the notice to appeal assailed that there was no evidence that accused number 1 was offered millions, and he arranged for accused 3, 6, 7, 8, and 10, and 12 to assist. In this regard, the evidence of the investigating officer in his affidavit started off with him saying, my investigation revealed that accused 1 was promised 7 million rands to orchestrate the escape. He enlisted the assistance of his co-accused, that is being accused 3, 6, and 7. The court did not misdirect itself in finding that there was such evidence submitted. Then it goes further at paragraph 21. It's in the same vein. That's where it says, the court had in contrast the evidence of Colonel Flynn, who stated that the appellant was found in Tanzania, that's the appellant here is Ms. Makuduman, on the 7th of April, without having used her passport to cross the various borders to get there. In this regard, there is also a statement of a witness which states that the appellant, under false pretenses, requested her passport, which was found by the police in Tanzania. The affidavit of the investigating officer further indicated the various means that the appellant made to claim the body, which was to be used to facilitate Thabo Besta's escape. In the process, even making use of the legal process to facilitate claiming the body as Thabo Besta and requesting an interdict against the police. So she was so brazen that she came to court to try and force an interdict to claim this body falsely. The state contended showed that the appellant is a flight risk with no regard for the law and no bail condition would have any effect. The fact that she was able to enter other countries without having her passport stamped shows her know-how of how to evade being traced. The appellant's behavior challenging her return is contrary to the behavior expected of a person kidnapped, and she never in all of this time took steps to report same, thus according to Colonel Flynn, calling her kidnapping into question. Now when they conclude on this, they conclude on all of these portions I have cited at paragraph 24, where he says, the court had regard to the evidence that was presented by the state that the appellant vacated her house that she was renting prior to leaving. Her movable assets were removed and no evidence from the appellant's side of what happened with her property. In the face of the state evidence that she removed it prior to leaving, the car which the appellant rented was found outside the borders of the country. Her own car was not used. I think the charge was that it was found in Zimbabwe. The appellant submitted evidence of a friend offering her an alternative address. There was no rebuttal in regard to this evidence of the state. This evidence was considered by the court a core in making its conclusion. And then look at what happens next, and this court cannot fault it. So all of these were presented in the bail hearing. The magistrate accepted them as being sufficient for the purposes of denying bail. They were then affirmed by the High Court in the appeal. So both the Supreme Court of Appeal and the High Court have made very clear authoritative statement of fact about what the evidence is right now. Now it would be absurd to say that the media cannot repeat. The media is not repeating the findings of guilt. It's repeating the conclusions that have been reached by judicial officers who were entrusted to look into the bail and to look into the so-called irregular arrest of Dr. Makuduman. And the three statements that we looked at the beginning all fall under the categories that have also been endorsed by the judicial pronouncement. So not only has these issues been judicially pronounced, they have also been the subject of extensive media coverage. And when I say extensive, I don't exaggerate. And I'm not going to quote these articles because they're not as crucial as the judgments. But I want just to refer the court to where they appear. So there's a BBC article of the 20th of April 2023, which is at 005/89. It's entitled Thabo Besta, the South African rapist who faked his own death to escape prison. Then you have another one from The Conversation at 005/98, entitled Thabo Besta's escape from a privately run South African prison raises questions about corruption. Then you have a Ground Up article, and Ground Up was the pioneering news outlet that ran with the story. You have that at 005/102, which explains why we investigated the Thabo Besta story. Then you have the City Press at 005/105, how Thabo Besta was arrested and released by shady cops shortly after his prison escape. And then you have again the Ground Up at 005/111, Police Minister confirms Thabo Besta was detained and then released while he was on the run. And then there is then a fuller article at also by ground up at 005/117. That article is actually important because it sets out all of the evidence that was uncovered by Judge Cameron, which was then presented in Parliament. And it details it in sequence about what the Judicial Inspectorate found, and that you will see at 005/117. So what you are dealing with here is this story has been written about so many times. It's captured the attention of the judges, and they have made findings of fact on it. And so this documentary that we are talking about today is probably an insignificant piece of this puzzle. And it does not introduce on what has been alleged here anything new. It simply repeats what is already out in the public. And the story of Judge Cameron has been repeated so many times. And the question that is asked by the father, I can't imagine my daughter to do this, would be asked by any parent, and that will not imply any guilt. And the question whether or not Dr. Makutumana is a victim or an accomplice is a legitimate question in the light of all of these facts that I have illustrated. When a criminal suspect goes to court to say, I don't like the way the media is portraying me, because that's going to influence the judges, which is what we are dealing with. We've got two criminal suspects. They say, well, I don't like the way this documentary is portraying us, because that will influence the judges. What the High Court has found in the Brown case is that you should reject that argument, because you must presume that the judges are independent. They are not going to be influenced by the media. You'll find that at paragraph 105, and this is what it says: the presiding officer is a trained official who knows the justice system and who is impartial when he or she is sitting in their official capacity. A judge is a person of high integrity and honesty. Judges take an oath when they are appointed to uphold the law and to administer justice in an appropriate manner. Then again at paragraph 109, quoting the Bangalore principles, the principle relating to impartiality states that impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but to the process by which the decision is made. A judge shall perform his or her judicial duties without favor, bias, or prejudice. Should a judge find himself or herself in a situation where they are not able to be impartial, then the principle states that the judge will take the following steps, and those are about recusal. So the Arthur Brown case is then determinative of how would a media narrative, as it has been called in this application, impact on the judge. And again, one must distinguish between what the public thinks and what a judge thinks. A judge is insulated from public influence. The Section 35 right is about what the judges will think. And there we've relied on the Arthur Brown case. The other case that is obviously determinative is the media television case, which has been referenced already. What that case really is about, it just says in paragraph 19, that look, if you have a scenario in which a criminal accused comes to court, they try to stop a publication in the form of a prior restraint, which is what we are dealing with here. Firstly, you should not allow them to speculate about the harm. They need to demonstrate the actual harm that will eventuate. The word that is used is will eventuate, not might eventuate, but it says will eventuate. Now, they can't do that here because the three statements that have been cited are neutral statements that don't implicate anyone. Number two, there are already judicial outcomes that have been pronounced on the issue. Number three, there are already a number of articles. And then number four, most decisively, a judge is trusted because of integrity and impartiality. They are able to separate out the noise from the facts. So that's media television. And then there is another case that we found, a case of Manda Manyatse versus Mail and Guardian, which is to the same effect. It's also a Supreme Court of Appeal judgment. I just want to see if my we'll find the reference now. So paragraph 19 and 20 also makes the same point, that if you have a criminal accused who tries to interdict a publication on a prior restraint basis, the judge should not lightly grant that. The judge must ask, in what way will this impact the judge, bearing in mind what we know about judicial independence. So that's then Media Television, the Arthur Brown case and Manda Manyati case, I think are decisive on this point. Yes, the case is Manyatse, Manytshe versus Mail and Guardian. It's 2009 ZASCA 96. It's published on the 17th of September 2009 on Safli. And then the relevant paragraphs is 19 and 20. So the law is pretty clear on this. No speculation, no conjecture. Demonstrate the actual way in which a trial will be impacted. But in doing so, you must bear in mind that a judge is trained and has a forensic mind and will not be influenced by the public. So that takes care then of the Section 35 complaint. You then have a second complaint, which is what about defamation, that the documentary basically defames us. Now, it is an impossible argument to run. Thabo Bester is a rapist and was sentenced to life. And he's also a murderer. The fact that the documentary repeats that he is a rapist and a murderer cannot defame him. Now, there is a fact that has been established by the Supreme Court of Appeal that he escaped from prison. So that cannot, if you report that he escaped from prison, because paragraph 2 of the Magudumana judgment says that he escaped from prison, that also cannot defame him. And he does have a remedy if he has been defamed, and the remedy is a damages claim. And then you ask yourself, what is the defamation to Ms. Magudumana? It's just no defamation whatsoever. Then you have a third claim, which is the claim of equality. This is a bizarre argument because it's not clear, because the starting point for equality is the comparator. It's not clear what they are comparing themselves with, because they are not saying we're being treated differently to other criminal accused who are similarly situated. They can't claim.
I'm not sure I heard any argument on that. Can I just hear? Are you proceeding with the equality argument? Can I first hear from him, perhaps? Okay, you're on your feet.
My lady, truly speaking, there are a lot of certain things that are being said that we didn't say, but I was reserving that for reply, because every time I'll be on the stand saying that this is not what we are saying. So there must be a distinction between what...
I'm asking you a simple question.
Okay.
Are you proceeding with equality?
Yes.
Are you?
Yes.
Okay, thank you. You, counsel, because I didn't hear anything in argument.
Yes, we are proceeding. We still maintain the reason that we brought forth before this court.
It's based on equality. One of the
one of the prima facie rights we are raising is we are speaking about is right to equality.
Okay, thank you. Yes, then you'll have to answer.
Thank you, Minute. So, I mean, the short answer is that there is no prima facie case based on equality, because the first starting point of equality claim is a comparator, and they cannot draw any comparator. In fact, what's happening is that Netflix is treating them precisely the same way it would have treated any other subject of a documentary. Then there is a next argument, which is a dignity argument. That again was not mentioned orally, but it seems to be tied up with defamation and the fair trial rights, and the arguments I've made on defamation and fair trial would equally apply. The next one is about consent and approval. Now, they seem to suggest that they have a right, effectively, to veto the documentary. If they said no, the documentary wouldn't be published. But there is no subject who has any entitlement to veto a story. about them, particularly a notorious figure. Otherwise, if you started giving people the right to veto a story, no adverse stories would ever be written about anyone. Then you have an issue about prior comment. There is no right in South African law of defamation that a subject of a story is entitled to comment before the story is published. And no right is established here at all. What has happened is that Ms. Makutumana has distorted the contents of the agreement and suggested without any evidence that it gave her the right of veto and prior comment, but it didn't. But she was, in any event, invited to comment. She was invited to give her own story on the documentary, and she elected not to, but she was specifically invited. Your Ladyship will see I just want to get the correspondence on this issue, those letters of August and January. Yes, I think I found them. So yes, Your Lordship will see at 004/195, 196, 197, 198. When it comes to Ms. Makutumana, and I'll deal with them separately, we need to look at the facts holistically. On the 8th of January 2025, if Your Ladyship could have regard to page 004/197. On the 8th of January 2025, Mr. Machini Mutlaung, who was at the time the attorney for Ms. Makutumana, wrote a letter to the documentary makers, an email, and this is what he said. He says, I have been informed by Thabo Bester's legal team that there is a clip doing the rounds involving the documentary in which Dr. Makutumana's father is being interviewed. And then if you skip the following second, third, fourth, and you go to the numbered one, he says, I have the following serious concerns regarding the above. Number one, the recording of Dr. Makutumana's father without his legal team giving permission on the content is prejudicial in many respects. Number two, we specifically requested that any interview that is to be conducted in the name of our client should first receive our consent, particularly the content of such interview. Number three, we specifically requested and agreed that no part of the documentary should be shown before the current legal cases involving our clients are finalized. So that was the demand that he made on the 8th of January 2025. That demand was then responded to by the documentary makers at 004/196 on the 3rd of February 2025, in which at the end of that page it was made clear the following. I can also confirm that the interview with Mr. Sekeleni, that's Ms. Makutumana's father, was conducted in accordance with the relevant releases and in consultation with the legal representative of Mr. Sekeleni, whom Bonelela had referred us to, Mr. Ryan Ishmael, and such an interview will be used accordingly. So the fact is, as early as the 3rd of January 2025, they knew that the demands that they had made, that they want to comment before the documentary is released, that they don't want Mr. Makutumana's father to be interviewed, and that they would like the documentary to be played after the trial. Those are the demands they made. They were rejected on the 3rd of February 2025. Now, the documentary makers continued, of course, because a demand has been made by an attorney, it's been rejected. Nothing happened until the 20th of August. And why did things change on the 20th of August? It is because the trailer went out. But if you want to seriously think about when did the agency in this case begin, It began as early as the 3rd of February 2025 when the demands were rejected. Then they waited for 7 months without doing anything, without demanding access to the documentary, trying to stop the documentary, nothing. They then come out of the woodwork on the 20th of August 2025. And the letter now is coming from Dilana Reid, no longer from Mr. Mutlowung, and that you will find at 005/62. Now, Ms. Dilana Reid introduces herself at paragraph 2 there as representing both Thabo Bester and Dr. Makuduman. And then she says, I act for Thabo Bester or Tom Kwana. She says I act for Tom Kwana.
Counsel, please repeat the page number.
005/62. Oh, sorry, in Bester's case.
Okay.
Yes, I think that's why. In the Makutumana case, it's 001/63.
Thank you.
Yes, thank you. So if you go to paragraph 2 of that, she introduces herself as acting for both of them, both Ms. Makutumana and Mr. Bester, and says for Ms. Makutumana, she is instructed on bail and civil matters, and then goes on to make various demands. And paragraph 7, paragraph 10, and then paragraph 12. All of the demands that subsequently made it to this application are then repeated therein. These are then rejected the following day by Willem de Klerk attorneys, who are the attorneys for the documentary maker. 21 August 2025, and that you will find at 005 maybe I should use the Bester, 001/68. Yes. But those demands are then rejected. And you will go to paragraph 12, you will see there that insofar as your letter contains demands by Bester, same is rejected. So by the 21st of August 2025, both Ms. Makutumana and Mr. Bester know that the demands that they have made about the documentary have been rejected. They don't go to court immediately thereafter. Instead, a different attorney now comes to the scene on the 22nd of August 2025. And now that is the current attorneys of Mr. Bester. That is, I think it's Courage Morero and Mwekets at Annexure AA4, page 005/70. And they asking for what is called a cease and desist. And then there they make it clear that they will institute legal proceedings. That is on behalf of Mr. Bester. But we know those legal proceedings are not instituted immediately thereafter. Those legal proceedings are instituted only on the 29th of August. Having first demanded that they would be instituted on the 20th, rejected on the 21st, demanded again on the 22nd. But they then wait for another 7 days before they institute those proceedings. And the problem with that is that the period they then give the respondents to answer is a very truncated period, which is not commensurate with the time that they took to initiate proceedings. So that would then become an instance of self-created urgency. You waited too long, even if you had any rights. You just took too long to come to court. They also created a further problem, Mr. Bester's attorneys. The practice manual in this division requires all the pleadings to be finalized on the Thursday at 12 o'clock for a hearing on the following Tuesday at 10 o'clock. But they put in the notice of motion that the answering affidavit should only be submitted on the Thursday at 2 o'clock, leaving no time for the replying affidavit, no time for heads of argument. Now, the reason why we raise this, we're not trying to nitpick. If you're going to run an urgent application, there are three players you must think about. The one is prejudice to the opponents. Number two is courtesy to the judge. And then number three is compliance with the rules. What they did, they ignored compliance with the rules. They were discourteous to the judge that's hearing the matter. And they ignored prejudice to the respondents. They basically just did as they pleased. Nevertheless, Netflix took the view that it has a documentary on the 12th that it wants to flight. It does not want this documentary to be held up because Thabo Besta's litigation strategy is clear that it is not expeditious in its nature. So it is going to answer as soon as possible. So it will file an answer earlier than required, and it would file its heads of argument earlier than required. What happened here is very odd. We filed our heads earlier than the applicants. Applicants came with their heads later, which comes back again to the fact that you are running an urgent application with total disregard of your opponents, and with disregard of the rules, and with disregard of the judge. Now, the same applies to Ms. Maguduman. I have already shown the judge that Ms. Magudumana's attorney, Machini Mutlaung, already told us on the 3rd of February, on the 27th of January 2025, what his demands were. Those were already rejected on the 3rd of February. Nothing was done. We then get on the 20th of August a letter written on behalf of both Thabo Besta as well as Ms. Magudumana, making certain demands, which are rejected the following day on the 21st of August. The papers are not instituted at all until the 7th of September. From the 21st of August until the 7th of September, giving Netflix, in effect, 1 day to respond. 1 day to respond. They are told by Judge Mudau that your case is transferred to Pretoria, ensure that you get a case number. They spend the whole day without getting a case number. And they cannot explain why they didn't get a case number for the whole day. Thereafter, they don't file a replying affidavit. It should have been filed at least yesterday. In fact, the directive was that make sure that everything is done the day before, so that, and the reason again is that second element, courtesy to the judge. The judges in this division are very busy. They have many other cases. So you have to give them at least a day's courtesy to read the papers. The replying affidavit came to us last night at about 11 p.m. It was unsigned and it had many ellipses, those dots, incomplete and unsigned. The heads of argument, I saw them this morning. And this is why we say to your leadership, whatever your leadership thinks about the merits of this case, this is a classic instance of an abuse of process, of two litigants that are going to litigate the way they want, according to their pace, according to their rules.
Jonah? Sorry about that, my pen's dried up. Yes, you may proceed.
Thank you, my lady. So the manner in which the litigation has been run has been in disregard of the rules, discourteous to the judge, and in disregard of the prejudice to the respondents. Now, we have been in this situation before. You then have to look at how have they responded. In other words, how have they explained themselves? What you find is the most astonishing thing, where they are so blasé in their explanation. They say it's very difficult to consult with Ms. Magudumana. She's in prison. She doesn't have the rights like all of us. But it is her who decided to bring an application. So when she brought the application, she knew that she had the constraints of being in detention. And there are no excuses that people that are in prison must litigate according to different rules. They must litigate according to the same rules. But the important issue is the blasé nature, the devil-may-care attitude that they bring along when they have to explain. When we have been in situations like this, your client has come to you late, and you know that this is a big problem for the judge. What you do, you become candid, and you explain yourself forthrightly. What you don't do is the arrogance that they have exhibited. Now, this is why we then say, when you look at the conduct of the attorney in running this litigation, it's the kind of conduct that warrants a punitive cost. And you know what they said, my lady? They said that you have to look at what Judge Stuart Wilson did in the case of Showmax. Judge Wilson didn't grant them costs there. What they were trying to do is what they're doing here now, which is to interdict a documentary about themselves and this daring escape. That is not a reason not to give costs. It's a reason to give costs, because it means they don't learn from judicial pronouncements. They've been given a leeway by Judge Wilson, and notwithstanding that, they have abused that leeway that they have been given by Judge Wilson. So which means that this is now the point at which the judges stop giving the leeway and actually stamp their authority over these litigants. So, my lady, the case should be struck, both of them should be struck for lack of urgency. The costs in relation to Mr. Bester should be costs on scale C. Mr. Bester must pay those costs. The costs in relation to Ms. Makudumana should also be costs on scale C, but we ask your ladyship to seriously consider a de bonis cost order. And I don't say this lightly, because attorneys are also officers of the court. They bear the obligation to assist all of us to litigate in this court in a dignified way.